Hey guys, Jacqueline here with Zenith Home Loans. So today we are going to talk to my friend Rachel Kranz Caldwell. She is a family law and estate planner, and she started her own company a couple of years ago and came up with a couple of really good questions that I thought might be beneficial for everybody that I know that's owns a home or thinking about buying a home, and just kind of all the nuances and what that means for your estate and long-term planning and things like that. So Rachel, thank you for being here with us today.
Thanks for having me.
Absolutely. So why don't you maybe just take a couple minutes or seconds to just kind of tell us who you are, how you got into your field, and then we can jump into a couple questions.
Yeah, sure. So my name is Rachel Kranz Caldwell. I am a shareholder at Cline, Caldwell LLP. We are a family law and estate planning law firm. We primarily focus on family law litigation and mediation. We also prepare prenuptial agreements and then estate planning documents.
Awesome. And how long have you been doing this for?
I've been practicing for 11 years. We started our firm in January 2019, so just over 2 years.
Awesome. And that's when we started Zenith. So there you go.
Yeah, right around the same time.
Very cool. Okay, cool. So let's kind of jump into it. So one of the big questions that I get a lot from clients is, if I'm not married, but my partner and I want to buy a house, like what can I do? Is it smart to do from your side of the table? I know what it looks like on the mortgage side of the table, but from your side, like what does that potentially look like? And what kind of questions should we be asking as the potential home buyer and things of that nature?
Yeah. I mean, certainly it's a great thing to do. And it's a great investment to make. You just have to do it smartly. I think the more you have in writing, the better. So anybody who's not married that's buying a house together, we would recommend that they enter into a cohabitation agreement.
Okay.
So it's kind of along the lines of a prenuptial agreement, but you're saying we're not married, we're not intending to get married. But while we own the house together, this is how we're going to pay for the down payment and purchasing the home. Then also, how are we paying for expenses while we're living happily ever after under the same roof? And then also, if we no longer live happily ever after and we need to end our relationship, what happens with this house? So kind of getting ahead of it, it's similar to, and we'll talk more about this when we talk about prenuptial agreements, but entering into agreements with someone when you like them and you're still getting along with them and you're on the same page about things, instead of on the back end when you no longer, agree and can't stand the side of their face.
Yeah. Probably good to have those conversations when you like each other versus when you don't like each other.
Yeah.
And so let's say I do that. And let's say I buy a house with my partner and we have this cohabitation agreement. And then 2 years from now, we decide to get married. What happens to that cohabitation agreement at that point? Do we convert it into a prenuptial agreement, or does it just kind of go away?
That would be my recommendation, because, I mean, it doesn't go away. It's still a contract. Typically, the agreement would say, once we get married, if we ever get married, this is null and void, or it's not. If it's silent, then it still applies, because in Colorado, anything that you come into the marriage with is your separate property, and then anything that you acquired during the marriage is marital property. So technically, that was each party's separate property before they got married. But my recommendation would be that you say, okay, we're setting that agreement aside and doing a prenuptial agreement instead.
Okay. And so then that would lead me to my next question. Then let's say I own a home, I'm single, I bought my house 3 years ago, and then now I'm going to buy a house with my now partner, they're my husband. So what happens with the first house? So that was my marital property, or my property prior to getting married. But if let's say down the road, we got divorced, does that house 100% remain mine, or did they ever get any claims to it?
Yeah. So if you continue to own that house that you owned prior to your marriage, it stays in your name. It's only the increase in value during the marriage that's considered marital. So as you're the value of the home is increasing and you're paying down the mortgage on the property. So that equity is really, that whatever the increase has been during the marriage is marital. But if you take that property and add your spouse's name onto it, you've contributed that asset from a separate property component to now you've contributed it to the marriage. So you would be able to make an argument down the road when you're getting divorced that you made a major contribution to the marriage and therefore you should get some sort of reimbursement for this large contribution that you made, but you're not necessarily going to see a dollar for dollar return on that contribution that you made. So really the best advice is to keep it in your name, and then if you ever do sell it, continue to trace that asset into your own name. So depositing it into an account in your own name, or purchasing another property in just your name, or, depending on if you're married at that point, you may want to do a post-nuptial agreement before you go. And if you all agree, okay, we're each going to sell our houses that we owned before our marriage and buy one together, and one person is contributing a lot more equity from their property, because otherwise, if you take those separate pots and put them into the marital pot, then you've contributed that to the marriage.
Gotcha. Okay. So kind of once it's in the pot, it's there, unless there's a separate agreement. Okay, perfect. So that makes sense. And so with, I guess, kind of in the same lines of like the cohabitation agreement and like the prenuptial agreements, like, do you always recommend that there's a prenuptial agreement? Is there any scenarios where maybe one doesn't make sense?
Well, I'm a big proponent of them, although I will say I didn't get one for my own marriage. So, I think you have to assess the circumstances in your own relationship, but people will do them for a number of reasons. I think that they're great just for transparency and going into the marriage. Can't tell you how many people I represent on the back end when they're getting divorced who tell me I had no idea what my spouse came into our marriage with, or we kept our money and our spending separate. I have no idea even how much money they earn or what they're spending. So it's good to just really have that conversation and be transparent about that, because that's the number one reason that people are getting divorced, is because issues surrounding finances. So get on top of it before you're getting married. Be transparent about what you each have, what you're going to pay for, what you're contributing, so that you can avoid those discussions and disputes later on.
Okay.
But also, I think it's dependent on your circumstances. If this is a second marriage for people, if they have children from other relationships, that needs to be considered. Protecting what you've acquired before you're getting married. People are getting married later and later in life. And so they've already established careers and they want to protect those assets. If you're also intending that in the future, perhaps one spouse is going to quit their job and be a stay-at-home parent, you may want to go into the marriage with agreements and understandings about what that would look like if you were to get divorced and a spouse no longer has their career to fall back on.
That makes sense. And so that covers like the prenup, so everything beforehand. So when would you do a postnuptial agreement? Like, do you see that often?
They are becoming more and more, popular, I guess you could say.
Right.
Especially, I think with COVID, it brought a lot to the forefront with people and relationships, and you're looking at each other in your house because you can't leave. And do we like each other? Do we need to reassess things? So you can enter into a postnuptial agreement at any time unless there's a contemplation of divorce. So if you've already filed for divorce, you either then need to dismiss the case, work on your relationship, then enter into a postnuptial agreement or proceed with the divorce. So typically, sometimes people are kind of going down and exploring both paths. So you really need to have separate counsel for each. People can enter into a postnuptial agreement if they're kind of in a crossroads in their relationship and they want to say, okay, we're going to keep working on our relationship, but I need these type of boundaries and these agreements about how we're going to move forward, or what happens if it doesn't work out. Or if a spouse is making a risky financial decision, if they're entering into a new business, perhaps the other spouse is not quite on board with that. They may want to reconfigure how assets would be allocated if they were to ever get divorced. Those are typically the reasons that I'm seeing that come up more so, once parties are already married.
Gotcha. Okay. That makes sense. Okay. So let's switch gears from that really lively and joyous topic of divorces and prenuptial agreements. And let's kind of talk about maybe like trusts and living wills and like, what do we do? What's the benefits of those? And like, should everybody have them? And kind of what are your thoughts on those?
I don't necessarily think that everybody needs to have them. I think it depends on, where you are in your stage in life and what your estate planning needs are. If you have children, it's certainly something important to consider, because if you were to pass away and your children are going to be inheriting wealth, you want to make sure, that it's clear who you want managing that while they're still a minor, and then also how they would then inherit that once they're no longer minors, so that they're not necessarily coming into a large amount of wealth right when they, are no longer minors. So concern that a number of parents have. So with a trust, you can make clear what money can be spent on, and then also when they would come into, the larger sums of money, or ultimately whatever is left in the trust. So what I tell people is it's a way to kind of control how your funds are utilized after you've passed away, like from the grave, because you can make really clear in the trust what it's supposed to be used for. Right. While you're still alive, you can, manage a living trust and move money in and out of it. And so, people will have tax reasons for wanting to do that, or taking assets out of their own names. There's certain professions where people don't want their assets to be located, or you don't want to make it very easy for people to figure out where you live. So they'll put their home in a trust. Okay. So, I think it really depends on what your circumstances are, what your needs are, and where you are in life, whether or not you need to establish a trust or have one that would be established upon your passing.
Okay. And then what about like a living will? Is that more like end of life type of care? There's an accident or something like that? Or does that also apply to like finances and things like that? Or is it kind of all of it?
A living will is really what's also known as an advance directive. So that's making clear what you would want to have happen if you were ever to be determined by a doctor to be in a vegetative state, or if you needed artificial nutrition. So again, kind of taking those more difficult decisions out of someone else's hand and telling your loved ones what your wishes are, instead of people wondering, gosh, I wonder what they would have wanted now that they're in this circumstance. So with respect to if you're in those type of medical situations, then you'd want to have, you can also have a medical power of attorney, someone that's then appointed to make those decisions for you. And then also a financial power of attorney. So that's the person that then would be able to, pay your bills for you if you're not able to do so on your own, and make financial decisions for you, basically standing in your shoes.
Okay. And so what about if somebody, so like, let's say my parents passed away and they didn't have a will or a living will or a trust or anything like that. What happens to, because you hear people talk about, oh yeah, we're dealing with this estate and all that kind of thing. What is like, I realize it's a much bigger picture, but like, what's like the simplified version of what that really means? And then what, if it was me and it was my parents or my grandparents or something like that, is there anything I should be looking for to make sure it's done or not done, or basically just anything to call out?
Yeah. So if it's determined that there is no will that anybody's been able to locate, it depends on the size of the estate, whether you'd need to, pursue probate and open an estate through probate with the court in whatever county that they either own property in or passed away in. With respect to property, It's going to depend on how the property was titled. So, say your parents owned the property in joint tenancy with right of survivorship and just dad passed away, then mom now owns that property all in her own name, and the title just needs to be cleaned up. But then if mom also passes away without a will, that's then when you're going to have to, open an estate, and someone's going to have to be appointed as the personal representative to get the property sold and distributed amongst their beneficiaries, depending on what the family tree looks like. Is kind of a very broad answer.
Yeah, very broad. So best case scenario is somebody has either a will or an advance directive that says, here's what happens, here's where I want everything to go. So it's really just one of those, like, just kind of planning ahead as best you can based on what you have access to and what's best for your overall financial picture, and then adjusting it however often you need to based on maybe dynamic changes, career changes, family changes, things like that.
Yeah. So I typically tell people, once I've prepared their wills or trust, whatever estate planning documents that we've determined that they want and need, that they should really pull them out every couple of years and take a look and determine whether or not any changes need to be made. Have you gotten a divorce since then? Do you have more children? If you've appointed someone to be the guardian of your children, is that still someone who's important to that child and in your life?
Right. I feel like that's probably a big one.
Yes, definitely. Yeah. And I mean, so it's really easy to change those things. But it's obviously a lot harder if you then were to pass away and, someone's like, why am I supposed to be the guardian? I haven't seen this child in 10 years.
Right. Okay. That makes sense. So how much generally, and I realize you can't quote an exact number, but like if somebody was looking into maybe setting up a trust or getting a will or an advance directive in place, in general, what should somebody budget for something like that?
That is totally dependent on who you choose to work with. I know a lot of estate planning attorneys will do a flat fee cost.
Okay.
So that just depends on what their flat fee is. When I used to do flat fee work, I was typically charging between like $750 to like $1,000, depending on what it, what documents I was preparing for people. But I actually realized that it was much more cost effective for clients if I charge my hourly rate, which is what I typically do with litigation work, and mediations. So I bill at $250 an hour for estate planning work. Okay. And, depending on how simple or complex it is, then, determines the cost. But I was finding that it's actually less expensive for people if I do it at that rate, and I can get a lot of the more simple documents done in even just an hour or two.
Okay. So that's good to know. And then let's see, you might have answered all of my questions. So we addressed what happens if there isn't a will and somebody passes away, or if I pass away. I guess, is there anything else that we haven't covered or that you don't feel like is covered in like a prenup or a will or a trust that will basically just make sure if I'm like looking at overall big picture and 20, 30 years down the road, is there anything else I should be considering to make sure that both myself and my family are taken care of well into the future?
I think what a lot of people don't realize is there's not actually a lot that can technically be in their estate that they would need to address in a will if they pass away, because anything that has a joint tenancy with right of survivorship designation is going to pass to whomever else owns the property, or if you have a beneficiary designation, so 401k, a life insurance policy, those assets are going to pass directly to whomever you've listed as your beneficiary and outside of your estate. So I think it's also really important for people to sit down and figure out, what do I have and what would happen to it if I passed away, with or without a will, to figure out what are we talking about as really actually in your estate.
Okay. So that's good to know. Anything else as far as like services that you offer or things that you wish people knew about your profession and kind of what else that you do that we want to make sure they know about today?
Going back to prenuptial agreements, I can't speak, more highly of them.
Right.
I can't speak enough about them. I think, again, it's just people making decisions about what would happen with the unraveling of their marriage when they're actually happy and on the same page. I think even if you don't end up signing on the dotted line, going through the process of doing the financial disclosures so you don't have big surprises later on, or you haven't become, accustomed to a lifestyle throughout a marriage that all of a sudden you realize was being supported by somebody else. And so it's not really something you can grab and get your hands on, at the end of the marriage is so important to just even look into, even if you decide it's not for you.
Right.
Also, we offer mediation services at our firm. And so if you're choosing to get a divorce, but you want to keep your costs lower and not each hire an attorney, we can help both of you draft documents and try and resolve your divorce more amicably. We wouldn't be able to give either party legal advice, but I think that's an option that more and more people are exploring and looking into. But I would recommend having an attorney involved in one way or another, either to represent you or assist you in a mediation, because we see so many people who use the court forms to get divorced and then end up having disputes later because the forms are really, a square peg that you're trying to fit into a round hole of every situation is so different.
Yeah. Well, and especially if you've never gotten a divorce before and you don't kind of know what that looks like. Same thing with mortgages. It's like, you're not going to do this hopefully very often, definitely not with a divorce situation. And so it's important to have somebody kind of like in your corner who knows it backwards and forwards, knows what's to look for and things like that. And I tell my clients all the time, anytime I've got somebody that's buying a house with someone they're not married, I always tell them to consider the cohabitation agreement, because I have had situations where they call me 6 months, a year later, and they're like, hey, we've split up. Here's what we're doing. And then I always ask them, like, did you happen to put that cohabitation in place? And so far, I've only had one client do it. And it worked out really well because they were at each other's throats. And it was actually not a partner situation. It was two friends that bought a house together. And one of the friends got engaged and they were having a baby, and the other partner moved in. And so now all of a sudden my client has this roommate, and that's a family that he wasn't prepared for. And they had it all the way down to who was going to represent them when they sold the property. And I'm like, perfect. Somebody actually listened to me. And as difficult as the entire situation was, because of kind of this friendship fallout, they knew exactly what was going to happen next. And I think it could have gotten a lot uglier. And so I think that prenup and those cohabitation agreements are really beneficial, even though it's maybe not something we certainly don't want to talk about, the demise of a relationship or the end of a marriage, but it's important to know, okay, well, what does happen though? And who gets what, and how do we do that in the most amicable way possible? Because like you said, I like you today. I may not like you in 10 years when we're talking about getting divorced, or you moved in your partner with the baby, and I don't really want a roommate with a baby right now. So those kinds of things. So I think it's all just about being prepared. So I really appreciate your time today, Rachel. I feel like this was really helpful. And I use your services myself. I have your paperwork at my house. I still need to finish putting it together, but I see the benefit of doing it. And I know it would be really beneficial for everybody to get this information. So thank you.
It's such a relief to have it done too. You're just like, woof, I can push that to the back. Most people that I work with for estate planning, it takes probably 6 months to a year, because that's just the task that falls to the bottom of the to-do list. And it's not a happy, fun topic. Fortunately, with prenuptial agreements or cohabitation agreements, we've got more of a pressing timeline that we need to get done. So it becomes more of a priority. But I mean, the example you gave is such a great example, because it's really a business relationship that you're getting into when you're buying a house, even with a friend or a significant other. Just like going into a marriage, it really is a business relationship. And even if you don't end up getting a prenup, I definitely recommend people keep documentation reflecting the value of their assets they came into the marriage with, because it's a lot harder to go try and track all of that down later. And I actually do tell people, because you have to do financial disclosures when you're getting divorced, and it's, aside from just the pain of getting a divorce, is the most painful part, I think, of the process. I always relate it to when you're applying for a mortgage, where we're just constantly asking for more documents.
We need more. Yeah.
Yeah. And, trying to track it all down, and you're like, why do you care about this account that has $5 in it? And so just keep all the documents that you had to gather for Jacqueline, keep them for
keep them for Rachel. Like Rachel's going to need this. I'll just start a folder on my desktop for all my clients to be like, hey, this is for Rachel for later when we move on to the next stage.
Exactly.
All right. Awesome. Well, I'll have Rachel's information in the comments section below so that you can reach out to her for any other questions. But again, I really appreciate you taking the time, and hopefully everybody got some really good information today.
Yeah, thank you.